I am Jeannine Broadnax. I am attorney and founder of S.T.E.P.S, which is strategic. So I'll start off telling you a little bit about myself. I am going into my 10th year as a practicing as an attorney, and within that time, the first half of that time I spent with the Cook County State's Attorney's Office here in Chicago, prosecuting criminal offenses, as well as helping juveniles and families receive services. So I did that the first half of my career. In the second half, I've been doing estate planning and working with families who have been able to take care of disabled people and help them get, property and things of deceased loved ones. So also during that time, I received a master's in tax law and estate planning. So I had my law degree, and so I went and did more schooling so that I would, really be specialized in this area and be able to help people. So that is, what I've been doing. So now what I want to share with you all is one of the first cases that I worked on while I was working at a law firm. So now in this case, there was a situation where we'll say Miss Jones. Now Miss Jones was an older lady. She didn't have any children. She lived alone, but she was, one of those type of people in the neighborhood that everyone knew, everyone loved, and, respected. So now Miss Jones had a will. So now in this will, she named one of the neighbors as the person she wanted to receive her house when she died. Since she didn't have any other family members, she wanted to have someone. So now Miss Jones died, and now the family member, will call her client. She came to our office and said, Miss Jones has died, and I have her will here, and it says that I should be the person who is to receive this house. So now because she had a will, it needed to go to probate. So we'll talk about probate, but right now I'll just continue on with what I'm telling you. So now we take the case to probate. Probate is when you have to go before the judge when a person dies and they have assets that are still in their name. You have to go and have the judge have those things distributed, basically to remove the asset from the deceased person's name to the name of the beneficiary, whoever is going to take. So that would be named in a will if the person had a will. However, if a person dies and they don't have a will, it'll go according to the laws of the statute. So now in Ms. Jones' situation, there was a will, and the will named the client as the person to receive the house. So we open the probate case, go to court, pay the money, pay the filing fees, and go through the process. And now we're in this process. We're going to find someone to buy the house. So now here's someone to come forward to say that they want to buy the house from the client, who's now going to be the owner of the house because she received it in the will. Now during this process, it was learned that there was what you call a land trust. So when you get ready to sell a house, there's a title search. So during this title search, there was a land trust that was on the house. So a land trust is controlling, because a land trust is a contract, and so contracts are valid. The agreement between the parties who signed it. So although she had a will, her mother had a land trust on the house, and Miss Jones didn't know, or maybe she forgot about it. It was so long ago. So at any rate, here now we have this land trust which says that the house is supposed to go to a relative. But as I stated, Ms. Jones didn't have any children. There were no other relatives that she knew of that was living. So now what do we do? And so the judge says, well, you've got to hire a company to find out, are there any relatives somewhere out there that, could be connected to Ms. Jones, because this is what the land trust company is there in court. And they're saying, well, we have to do what the contract says, which is that it should go to a relative. So now we hire this company. The company finds, I think it was a fourth or fifth cousin, someone that Miss Jones didn't know, but that was actually related to her, that lived, I think he lived in Florida somewhere. So now we send him notice that he has to come to court. He comes to court, and, we explain to him the situation. He doesn't know Miss Jones. He says maybe someone down the line had mentioned he had some people here in Chicago, but he never, he had no connection. So here you have my client, who was Miss Jones' neighbor and good friend, and she's thinking, okay, here we go. I'm gonna receive this house. And that's not what happened. My client did not, receive the house, although there was the actual will document that said my client should receive the house. So now, what Ms. Jones could have done to avoid that situation? There are a few things. if she had, initially she had a will instead of a trust. So now a trust is a document where you transfer the property into the name of the trust. So while you're alive, you already remove the items, the property, or whatever asset you have from your individual name to the name of the trust. So when you do that, you give notice to people. So if she would have done that, then she would have gave notice. She would have filed the document and let everyone know that this is who I'm putting my house in a trust, the beneficiary, the trustees, these are the people. And then when that was filed, it would have been noticed that that land trust was out there. And that at that time, she would have either decided to cancel the land trust because she didn't want it to, go to a relative that she didn't know, or she would have amended it and said, okay, well, I'm the only living relative now, so now we have to amend it to add, another person, a friend, a family. But she didn't know it even existed, and there was nothing that was done. And the attorney, when you're doing a will with an attorney, they don't, that's not necessarily their responsibility to then do a search for your property, a title search. But if you're doing a trust or you're filing a new deed, then that is the attorney's duty to also, do a search for the property as well. So, that was definitely a very unfortunate situation, because here Miss Jones was, she thought that she was prepared and that, she was on top of things and that she knew what she was doing and she had her wills and things together, but that wasn't the case. And the property, ended up going to someone that she didn't even know. So, it's really important to have a will. A will is where you can, distribute items, and you can say where you want, who you want to have things. You can also, if you have minor children, you can name who you want to be their guardian. So that's important to do. But now if you have actual property, a house or something like that, then I would suggest, doing a little bit more than a will, because you want to have the things, taken care of, and you want to have the asset properly transferred. So that's really important. And another important thing with estate planning is power of attorney. So now power of attorneys are important because that's actually a document that is good while you are alive. So if you become sick or if you become disabled, you want to make sure you have someone named as the person who, would be able to talk to your doctor, would be able to make decisions for you, would be able to, if there was an issue with the bank or with your apartment, with your landlord or something like that, then this person would be able to do it. Because, according to the law, every person, although if you're married, your spouse, they can help you make decisions. But sometimes, they want, depending on the agency, they want like a document that shows that, you are the person's caregiver, that you are the person, especially if the person is disabled, because they, I don't even know your name, sir. Mr. Kirby was saying that, that there is so much fraud and there are so many, different things that are, going on. And so because of that they have to make sure of these things, so that they have to put safety guards in place so that people can be protected, so that, that you can't get any information. You can't just pick up the phone and say, hi, this is, Kirby, and, and you're calling like you were saying, but you want to get some information about your wife, They want to make sure that you're not someone else that are, trying to, misuse this information. So there are definitely different, safety mechanisms that are, put in place. So a power of attorney is something that is good. And because, tomorrow's not promised to anyone. We don't know what may happen. And, sometimes people become sick and disabled, and not just immediate, death. And so that if you're not able to speak, you're not able to do these things, then it's important to have something in place. So that's a document which is called a power of attorney. So there's a power of attorney for healthcare as well as a power of attorney for property. So that's the person that is able to make, financial decisions for you. And also in the power of attorney for healthcare, there's the ability for you to make a decision if you want to receive life-sustaining treatment. That's important. That's important to think about, when you're in your right mind to make those decisions, so that you don't pass that on to someone else, a child or a friend, when you're in the hospital, and they want to make the decision, okay, well, would he or she want it to receive, life-sustaining treatment? Would you want to see the CPR? Would you want to be hooked up to a ventilator? Some people, I have all different types of clients where they say, keep me alive, do whatever you need to do to keep me right here. And so that's important for their family to know that. But then I've had clients where they say, oh no, I don't want anything. When the Lord takes me, just let the Lord take me, right on away. And so I don't want anything. And so that's important for their family to know. So whatever it is that your decision is, it's your decision. And that's the important part of estate planning, is that it's the decision for you to make while you are sitting right here in your right mind to make that decision versus someone else making that decision for you, or even worse, the court having to make that decision for you, So that is pretty much the majority of what I have to say. Does anyone have any questions based on, the things I said so far? It would depend on the assets, the property that you have. If you have a house, or you have stock, or if you have land, I would say yes, because what a trust does, it allows you to actually retitle those things. And so when those assets are retitled and you name them in the name of the trust, which has the trustee, which has the beneficiary, then that's done. That's a done document. It's a private document. No one knows what's in that document besides the trustee and the beneficiary, so it's not public. Versus a will has to be filed, so that becomes a public document, so other people will know what's in there. And then with the will, you can name who you want to receive these items, but it still has to go through the probate process. So then there's a judge involved. Then there's a period in probate where it's called a creditor claim period. So it's a period for 6 months where any creditors of yours would come forth. There's a publication letting them know that you died. So it's probate is a very public process. It's an announcement to everyone that you are deceased, and that if anyone believes that you owe them any money, they can now come forward and try to make a claim to that. And so then, the court, will evaluate the claims and things like that. So, and then in the end, at the end of the process, the property will be transferred to whoever you said in the will, but it's much longer versus with the trust. You would, the trustee is in the background doing all those things without any other involvement. So in that regard, I would say that, a trust is better because it allows you to keep your matter private and to deal with these items, to retitle them on the front end versus on the back end. Just to make sure that we're clear as to what she was saying, that because of those items are smaller items, those are what you call personal items, that a will can distribute those items without any problem and without any court involvement. So that the will, there's a person in the will named the executor, so that's the person you designated as the person to see out the will, your wishes in the will. Then it's their responsibility to make sure that your niece gets the jewelry, your nephew gets the dishes, whatever you have laid out in there. But if there are substantial property, real estate, land, stocks, portfolios, cars, things like that, then yeah, it would be best to have those retitled via trust.
Okay, gotcha.
And that's a very good point to do estate planning, because if you don't do estate planning, then it just goes according to the law, and according to the law, then your family would receive. But if you know that that's not what you want, you can be very clear and specify that in the document. It sounds harsh, but I mean the way it would be written is that you're disinheriting those people, and that's fine. Like you have every. No, right, exactly. They can, of course, they can try and say that, you weren't in your right mind and things like that. But I mean, those are things you talk about with the attorney, so that they put in extra safety mechanisms in place to make sure that no one can, override or contest it based on the fact that they're upset because you left them out the will. Right,
That is a trust and not a will.
That's both. Either way, if you don't have to, it is your decision. You don't have to gift anyone anything. You don't owe anyone, anything. Now, if you have minor children, then the law states that that they are to become part of your inheritance. Minor children, because with minor kids, because they have to be taken care of. The law is not going to allow you to disinherit a child that's a minor. But if we're talking about adults, then they can be disinherited. That you don't owe them anything.
Adults is 18 and over.
Exactly. With the bank account, that you really have a lot of control with that. You can either, You can either do it on the front end and add a name actually onto the account, so then it would be you and another person, or you can do what you call a payable upon death. So all banks have that. That's a document that the bank has, and it allows you to name a person as a beneficiary. So everybody in this room with their bank account should have somebody on there. It is a form that the banks, for whatever reason, they don't like to give that information, I guess, because that just means they can hold on to the money longer before they eventually have to give it to the estate, and so they get to have the interest exactly on your money. So they don't like to give that information, but everybody who has a bank account should have completed a form that is called payable upon death. It is a beneficiary form. All it is just says that when I die, that this is the person who should have access to my account, who can have the money in my account. So then at that point, they can come with your death certificate and get it. Because that does happen. People don't do that form. And so then the bank account just sits there, and it does, depending on how much money is in there, it may have to go through probate in order to someone to have access to that money.
Even though you delegated someone as your beneficiary?
Right. Because if you, so on the front, if you did a trust, then at that point when you execute the trust, you can then say, okay, I'm going to change, I'll complete that form to say my trust is the beneficiary, so that when you're deceased then the trust gets that money. Or you can actually, as I was saying, add the trust onto the account so that the trust is already there. Because the bigger picture, I guess, if you don't take away anything from today's talk, is that take away that if there is something that is in your sole name, that when you're deceased, it can no one can access it because you're your own person. No one is you. So this computer belongs to me. It's in my name. So when I die, someone can get it because they can just pick it up and take it. It's a tangible item. However, with my bank account, that is only in my name. That's at the bank. That's not as tangible. Someone would have to have a card. They'd have to have my password. They'd have to have some information. So in order for that to be able to transfer without the involvement of the courts, it would have to go through the process while you're alive. Because then you can transfer it while you're alive, so that you would transfer it already, put another person's name on there, put your trust name on there, things like that. But if you don't do that, and like I said, depending on the amount of money that's in there, if it's a small amount, some banks will let you do what's called a small estate affidavit, which is still something that your loved one would have to talk with an attorney about and go through that process to complete that document and have notarized for the bank to be able to transfer over that money. But that's a very good question, because bank accounts are, we all have, bank accounts, and so it's it is easy to put a person's name on there. I mean, it's literally just a form, and so we should do that. But the banks, they just don't push it. I mean, I opened up a new bank account recently, and so I did everything that needed to be done, and then I said, oh, well, where's the payable upon death form? The lady's like, what are you talking about? What form? And I was like, the form where I would be able to put a beneficiary. And she's like, oh, you want that document? Okay, we can send you that. I mean, it's like, really? Why don't you? That should be, I feel like that should be an automatic thing. But I mean, it just, because eventually they do have to turn over the money, to the state, or, obviously to family members and things like that. But while they keep it, they're accumulating interest, and that helps their bottom line. So thank you all for having me. It was good seeing you.